Welcome, distinguished guests, ladies and gentlemen. My name's Penny Matthew. I'm the Freilich Foundation Professor here at the Australian National University, and I'm delighted to welcome you to tonight's Alice Tay Lecture on Law and Human Rights, to be delivered by our very distinguished and eminently qualified speaker, Professor Gareth Evans. Before we commence, I'd like to acknowledge that we meet on Ngunnawal land. I'm honoured to be on the ancestral lands of the Ngunnawal people. I acknowledge the first Australians as the traditional custodians of this continent, whose cultures are among the oldest living cultures in human history. I pay respect to the elders of the community and extend my recognition to their descendants who are present today. I'd also like to acknowledge our very generous benefactor, Mrs. Valmay Freilich, who's with us tonight, and without whose generosity these events simply would not be possible. Thank you, Valmay. Our speaker tonight hardly needs an introduction. Professor Evans is our Chancellor here at the Australian National University. He's also a Professorial Fellow at the University of Melbourne, his alma mater, and President Emeritus of the International Crisis Group, which he led from 2000 to 2009. He was a member, of course, of the Australian Parliament for 21 years, a Cabinet Minister for 13, and Foreign Minister from 1988 to 96. He co-chaired the International Commissions on Intervention and State Sovereignty, which initiated the Responsibility to Protect concept, and on nuclear non-proliferation and disarmament. He's written or edited 9 books, most recently The Responsibility to Protect, Ending Mass Atrocity Crimes Once and for All, published in 2009. And it's a rare combination of experience, both practical and intellectual, that he brings to tonight's topic, implementing the responsibility to protect, lessons and challenges. Please welcome our Chancellor, Professor Gareth Evans.
Well, thank you, Penny, for that very generous introduction. Professor Alice Tay, whose memory we honour in this annual lecture, was a hugely intelligent, engaging, and above all, feisty human rights protector and law reformer, who I had the pleasure of knowing a little bit back as a law academic back in the ancient past when I pretended to be one myself, and in her capacity as President of the Human Rights and Equal Opportunity Commission in the late 1970s. I'm very honoured to give this lecture on a subject on which I'm sure, had she lived to see it evolve, would have been deeply and passionately engaged. And I do feel particularly privileged that this invitation should have come from the Freilich Foundation, which since its establishment in 1999 has played a hugely valuable role here at the ANU and in the wider community in encouraging and financially supporting the study of ethnic, cultural, religious and sexual bigotry and how it can be combated by educational and social programs. I'd like to warmly and publicly myself thank the Freilich family for the generosity, and again to welcome Valmay Freilich here this evening. We're absolutely delighted to have you here with us. The dramatic military intervention in Libya, authorised last month by the UN Security Council, has set alight again international debate on the question of when, if ever, it's appropriate for states to take coercive and in particular military action against another state for the purpose of protecting civilians in that state at risk of mass atrocity crimes, genocide, ethnic cleansing, other large-scale crimes against humanity or war crimes. From one perspective, the whole course of action taken by the Security Council in response to the events in Libya and the parallel action recently taken in Côte d'Ivoire has given extraordinary new momentum and new authority to the new responsibility to protect norm, which was unanimously endorsed in principle by the whole global community at the UN World Summit in 2005, but whose effective implementation in practice has been far from assured. But from another perspective, given growing anxiety that the Security Council mandate may be being stretched to breaking point by the current NATO operation, There is a real concern that events in Libya, far from setting a new benchmark for future commitment, will prove to be the high water mark from which the tide will now recede. It would be a profoundly unhappy development if there were to be a major retreat from what has been achieved so far. Acceptance by the global community of the new principle of the responsibility to protect, unanimously by heads of state and government in 2005, and overwhelmingly hard-fought UN General Assembly debates since then, has involved a profoundly important normative shift. For centuries, right up to the beginning of our own, mass atrocity crimes perpetrated behind state borders were seen essentially as nobody else's business. Now, at least in principle, they're regarded as everyone's business. And that acceptance, in principle, really does hold out the prospect that genocide, ethnic cleansing, and other major crimes against humanity and war crimes can be stopped once and for all in our time. But even if there's no backsliding on the basic issue of principle, that is only half the story. It's not just a matter of continuing to acknowledge the intellectual and moral force of the new norm, but actually implementing it in practice. So in this lecture tonight, I want to explore where we've come from, where we are now, and where we now might be going in relation to that implementation. And I should make it clear from the outset, if it's not already, that I do so not as a mere disinterested academic spectator, but as one of the original architects of the new concept in my capacity as co-chair of the International Commission on Intervention and State Sovereignty, which initiated it in 2001, and in my capacity as a rather passionately committed advocate of it in many different contexts, many different forums around the world ever since. I hope that has not hindered my capacity to analyse objectively the lessons that we've learnt over the last decade and the challenges that we face in the years ahead in ending mass atrocity crimes once and for all, but that, I guess, will be for you to judge. From the journey so far, I think the three biggest general lessons that we've learned are about the power of ideas, for good or for ill, the omnipresent reality of politics as both positive and negative force in international as in domestic affairs, and the necessity for more patience than most reformers possess if there is going to be lasting change for good. So, ideas matter. The problem before responsibility to protect was articulated was that for all the force of the human rights, humanitarian and human security principles articulated in the Universal Declaration, the Geneva Conventions, the Genocide Convention and elsewhere, when it came to mass atrocity crimes committed behind the walls of a sovereign state, there was simply no idea in international currency powerful enough to match the force of the very traditional concept of sovereignty thought to be embodied in particular in Article 2.7 of the UN Charter in its language, which said, and still says, nothing shall authorise the United Nations to intervene in matters which are essentially within the jurisdiction of any state. The only competing idea was Bernard Kouchner, the former French Foreign Minister's idea of droit d'ingérence, the right to intervene, or the right to humanitarian intervention. But while that had real resonance in the global north, particularly in the context of the genocidal catastrophes in Rwanda and Bosnia, it commanded only negative traction in the global south and simply could not generate the necessary consensus for action. The great achievement of the International Commission that I co-chaired was to identify a new idea that could compete in a way that humanitarian intervention had proved unable to, with the old, very narrow idea of sovereignty as immunity. The responsibility to protect, a phrase almost banal in its simplicity, captured two critical themes. The issue here was not anyone's right to act, let alone the big guys, but everyone's responsibility. And the action in question was framed not as to intervene, but rather to protect. As fully spelt out in the language of the later 2005 World Summit outcome document, it was even clearer that the responsibility to protect was not an assault upon state sovereignty so much as an embrace and refinement of that sovereignty. The primary responsibility to protect against mass atrocity crimes remained very clearly and explicitly under the articulation of the doctrine with the state itself. Others had a responsibility to assist that state in that obligation, and it was only in the case of that state manifestly failing to exercise its own responsibility that any more general obligation to engage, including if necessary through more coercive measures, would cut in. There's a lingering tendency in some quarters to argue that responsibility to protect is not a new idea at all, just old doctrine and, in some respects, even old practice in a new bottle. Certainly the idea of sovereignty as responsibility had been articulated and quite actively promoted earlier by Francis Deng of the Brookings Institution with his colleague Roberta Cohen in the context of internally displaced persons. It's also, when you think about it, manifest that the idea of limitations on the absoluteness of state sovereignty is inherent in the UN Charter itself and certainly the major human rights instruments. And it's certainly also arguable that responsibility to protect involves a political call for all states to abide by legal obligations which are already there in treaty instruments and in international humanitarian law. All true, perhaps missing the point. Substantive obligations were simply not being observed. Article 2.7 of the Charter was being given more weight than the rest of the corpus of treaty instruments put together. No one was actually using sovereignty as responsibility or responsibility to protect language in any generally prescriptive way. And the only conceptual framework for the intervention debate that raged throughout the 1990s in particular, the only conceptual framework was humanitarian intervention. That's to say, one-dimensional military coercion. Send in the Marines or do nothing, are simply the alternatives in debate. And about that, there was not only zero consensus, but a bitter international contest. What was needed was a political game changer, and what exercised the original commission was the need to find a way as simple as possible, and if it had some resonance in pre-existing literature and international law, so much the better, some way of re-articulating the issues which would build a bridge between the absolute sovereignty and the limited sovereignty brigades, getting them to find some common ground which had been previously conspicuously missing. The model that we expressly had in mind was Gro Harlem Brundtland's World Commission on Environment and Development, with which many of you will be familiar, which a few years earlier had come up with the bridge-building leitmotif in that context of, you'll remember, sustainable development. Didn't mean that there was going to be agreement about any particular policy response to any particular problem, but at least there was a common concept which each side, the greenies, the developers, could accept, and a level playing field conceptually on which to argue out the policy issues. And similar thinking lay behind our deliberate attempt to find a bridge-building phrase, which responsibility to protect has proved to be. A rather less subtle variation on the theme that responsibility to protect is not really a new idea at all is the suggestion in quite a good deal of the post-colonial and self-consciously anti-imperialist writing, of which we are now hearing, of course, some echoes again in response to the events in Libya, writing to the effect that the concept is simply old militarism in a new bottle. As someone said of me in the New Left Review at the end of last year, a facile rebranding of interventionist doctrine. But when properly understood, responsibility to protect and humanitarian intervention could hardly be more different. The very core of the traditional meaning of humanitarian intervention is, as I've already said, coercive military intervention for humanitarian purposes. Nothing more, nothing less. But although there is a risk of this being obscured again in the current debate about Libya, which is now wholly about the proper scope and limits of coercive military action, responsibility to protect is about much more than that. It is about taking effective preventive action at the earliest possible stage. It implies encouragement and support being given to those states struggling with situations that have not yet deteriorated to the point where genocide or other atrocity crimes are a reality, but where it's foreseeable that if effective preventive action is not taken, with or without outside support, they could so deteriorate. The concept recognises the need to bring to bear every appropriate preventive response, be it political or diplomatic or legal or economic, or in the security sector as well, while falling short of coercive action. For example, the preventive deployment of military personnel as in Macedonia in 1995. Of course, there will be situations where prevention fails, where crises and conflicts do break out and some interventionary reaction becomes necessary. But that doesn't have to mean military intervention. It can also involve political, diplomatic, economic and legal pressure, measures which can themselves each cross the spectrum from persuasive to intrusive, and from less coercive, like economic incentives, offers of political mediation or legal arbitration, to more coercive, for example, economic sanctions, political and diplomatic isolation, threats or decisions to refer to the International Criminal Court. Coercive military action can't be excluded when it's the only possible way to stop large-scale killing and other atrocity crimes, as few doubt was the case, for example, in Rwanda or Srebrenica. But it's a travesty of the responsibility to protect principle to say that it's about military force and nothing else. That's what humanitarian intervention was about, but it's not responsibility to protect. Politics. Ideas matter because they do have, or at least can have, if they're taken up, real political force. They provide a frame of reference, making it easier for policymakers to take one course rather than another because they can articulate clear reasons to the various constituencies that they have to satisfy. Getting a big new idea, more or less universally recognised as the appropriate way, the appropriate frame within which a particular problem should be addressed, is getting at least halfway toward ensuring that the outcome will be consistent with that idea. If one looks at a Rwanda situation through the lens of prima facie sovereign immunity from intervention on so-called internal matters, excuses for non-intervention are rather easy to find. Look at it through the lens of the responsibility to protect, and this becomes very much harder. In the minds of those of us who initiated it, responsibility to protect was designed from the outset primarily to have political effect. My commissioners were concerned to build new doctrine, sure, on sound philosophical and sound legal foundations, but our overwhelming preoccupation was with stopping mass killing, raping, forced population shifts, property destruction. The whole point of trying to craft a new conceptual framework for addressing mass atrocity crimes was to generate among international policymakers and those who influenced them a reflex consensus reaction when any such new case came along. A reflex consensus reaction that such man-made catastrophes were everybody's business, not nobody's, and to energise effective collective action accordingly. Given that action-oriented political focus, the Commission tried to design and express the responsibility to protect concept in a way that would guarantee it the maximum possible take-up and real-world impact. But I have to say that we as a Commission had ourselves something more to learn in this respect. There were some conceptual and presentational refinements that needed to be made if it was to have maximum political force and effect, and that's exactly what took place between the publication of the Commission's report in 2001 and the actual embrace of the principle at the World Summit, the UN General Assembly sitting at head of state and government level in 2005. And that process has continued to some extent with the further articulation of the issues in the Secretary-General's reports, which have been prepared by his advisor Ed Luck and debated, with practically no dissent now evident on the key issues, by the General Assembly in July 2009 and again in August last year. One important step in the evolution and refinement of the doctrine as compared with its original articulation was to define the threshold for the application of responsibility to protect more narrowly in terms of the four crimes, so-called, that I mentioned: genocide, war crimes, ethnic cleansing, crimes against humanity. The Commission report while essentially focusing on that same group of mass atrocity crimes, had used a rather more broad and ambiguous formulation. What we said was, quote, a population suffering serious harm as a result of internal war, insurgency, repression, or state failure. And that made quite a few states very nervous about the potential overreach of the doctrine. The second change, and I go through all this because there are perhaps a number of academics among you who've made a living out of drawing attention to the parsing of differences between the original report and the later one, and saying, for example, that as it's evolved, responsibility to protect is R2P light, and the real concept was in the original Commission report. Stuff and nonsense, I'm afraid, because I'm totally relaxed about the evolution which occurred. That's the real world at work. A second change, which was again more presentational than substantive, was to characterise the relevant responsibilities in terms of three pillars, with what was implicit in the language of the outcome document in 2005 being even more explicit now in the 2009 Secretary-General's report. I've already hinted what those three pillars are, but let me spell them out. Pillar one is the responsibility of each state to protect its own population from the atrocity crimes in question. Pillar two is the responsibility of others to assist it to do so, if it's in a mood to be assisted. And pillar three is the responsibility of the wider international community to respond in a, quote, timely and decisive fashion, and by all appropriate means, not excluding coercive military action in accordance with the UN Charter, if this becomes necessary because the state in question is, quote, manifestly failing, unquote, to protect its people. Characterising the different responsibilities in this way has, I believe, been extremely helpful in practice in getting the great majority of states to understand and accept what's involved. And I say again, my own commissioners have not been at all unhappy about the way in which the concept as originally articulated has evolved in response to the need to gain the widest political acceptance. It certainly would be desirable, and I say this for the international lawyers among you, it would be certainly desirable if over time the various layers of responsibility built into responsibility to protect doctrine, as now articulated, were to evolve into rules of customary international law, as distinct from being simply as they are now, at least for states other than those in which the crimes are occurring, where there are rules, of course, of international law applicable, as they are now, simply normative principles of political and moral weight, but not legal weight. But that will depend on just how comprehensively the new norm is implemented and applied in practice, as well as recognised in principle in the years ahead. So the third big lesson we've learned, patience. Patience matters. In this respect, as with more immediate issues about impact and practical effectiveness, I think it is important that advocates of the responsibility to protect fully internalise and act in accordance with a lesson that we should have all learned by now, that this is going to be a long haul, with progress slow and often disappointing, and no doubt with some reverses occurring along the way. Until the recent developments in Libya and Côte d'Ivoire breathed dramatic new life into the norm at the highest international level, patience certainly was being demanded. Obvious successes in the implementation of the norm were pretty thin on the ground, with probably only Kenya in early 2008 being the only really clear example of the responsibility to protect playing an important energising role in stimulating an effective response to what you remember was a rapidly emerging large-scale atrocity crime situation. With that international response, interestingly, taking here a diplomatic rather than a military solution form, reinforcing the point I've been making, that responsibility to protect is not just about sending in the guns. Failures or weaknesses in implementation are easier to identify in recent years. Darfur is a case where the international community's response has been from the outset and remains much less focused and effective than it could and should have been. Although I think it is fair to say that it was, of course, only in 2005 that responsibility to protect emerged as an accepted international principle, as distinct from a gleam in the eye of people like me, whereas most of the damage in Darfur was actually done earlier, in 2003 and 2004. But Sri Lanka in 2009 was another case where the international community did, I'm afraid, largely drop the ball, as has now been abundantly documented with the just released report of the Secretary-General's panel of experts on accountability in Sri Lanka, which is an appropriately devastating indictment of the Colombo government's callous irresponsibility in the conduct of its final military operation against the Tamil Tigers, and by extension of the failure of the international community to respond effectively while there were still innocent lives left to save. The Democratic Republic of the Congo can perhaps be regarded as another less than conspicuous success for the operation of R2P, although it has to be acknowledged that the UN, the European Union, the African Union have made large-scale efforts to halt the slide into further violent chaos. And the problem is that in that continent-sized country, the problem is that the problems are just nightmarishly intractable. The lesson, for one, that I have drawn from these various disappointments, and others along the same lines, although it's been a hard line to sell, is that this means not that the responsibility to protect norm was inherently ineffective or irrelevant. Rather, it was just that we had to do a lot better about applying it in future. Well, the patience of responsibility to protect advocates has now been rewarded in abundance, as I hope so too will our confidence in the doctrine's future with the recent developments in Côte d'Ivoire and Libya, both of which, as you know, involve Security Council resolutions approving military force, or in UN speak, all necessary measures, quote unquote, to secure civilian protection objectives in the context of atrocity crimes being committed, atrocity crimes being feared. The Côte d'Ivoire intervention, which has come now, of course, to a more or less successful conclusion with the defeat and apprehension of the resisting Gbagbo forces 3 weeks ago, was a bit complicated by a number of legitimate agendas running simultaneously. Regional organisation action to enforce a democratic election outcome, and a UN mandate which went beyond just civilian protection to extend to force protection of the military international forces there present. But the Libyan case has been, at least until now, an absolutely textbook case, example of the responsibility to protect norm working exactly as it was supposed to, with nothing else in issue but stopping, continuing, and imminently feared mass atrocity crimes. Muammar Gaddafi's forces, you remember, responded to the initial protests, peaceful protests, against the excesses of his regime by massacring on the ground and from the sky perhaps more than 1,000 of his own people. That led to the first UN Security Council resolution, number 1970, February 26th, which specifically invoked the Libyan authorities' responsibility to protect its population, quote unquote, condemned violence against civilians, demanded that this stop, and sought to concentrate Gaddafi's mind by applying targeted sanctions, an arms embargo, and the threat of International Criminal Court prosecution for crimes against humanity. Then, as it became apparent that Gaddafi was not only ignoring that resolution, but planning a major assault on Benghazi, in which no mercy whatsoever would be shown to perceived opponents, armed or otherwise, his earlier reference to cockroaches having a special resonance for those who remembered how Tutsis were being described before the 1994 genocide in Rwanda. With all this, the Security Council followed up with Resolution 1973 of the 17th of March. This also explicitly invoked responsibility to protect as a principle, reasserted determination to ensure the protection of civilians, deplored the failure to comply with the first resolution, called for an immediate ceasefire and a complete end to violent attacks against and abuses of civilians, and then, in an historic first, explicitly authorised military intervention by member states if necessary to achieve these objectives. The coercive military action was allowed by that Security Council resolution to take two forms. all necessary measures to enforce a no-fly zone, and all necessary measures to protect civilians and civilian-populated areas under threat of attack, quote unquote. Only a, quote, foreign occupation force, unquote, was expressly excluded. And that was excluded because that was just a bridge too far for the Arab League to contemplate. And the political support of the Arab League was absolutely crucial in ensuring that there was both a majority on the Security Council and no exercise of a blocking veto by Russia or China. That regional support, let it be acknowledged, was also an absolute precondition for the United States, I think quite understandably, to be able to act without laying itself open to the allegation throughout the Arab Islamic world of being up to its old in Iraq invading regime change tricks. Part of the problem for the United States in being as tough as it might like to be now in the almost equally troubling civilian protection case of Syria is that there's no sign at all at the moment of any regional consensus in favour of military action there. But just as the lesson that politics matters takes here another form, so does the lesson, again, that patience matters. Frustration, as we can all see reading the world's media, is growing, that Gaddafi is still holding on, still menacing civilians in areas both within his own control and held by the rebels. The no-fly zone and other military measures employed from the air or at long range have not delivered a knockout blow. The neutralisation of heavy Gaddafi weaponry by airborne attack has not levelled the playing field sufficiently to give the rather poorly organised rebels any evident capacity to win on their own. The prospect of a stalemate looms large. And with all of this, there are many strident voices saying that the United States and NATO should up the ante accordingly and wage all-out victory for all-out war. Wage all-out war for all-out victory. But as NATO responds to those pressures by stretching its UN mandate to the absolute limit, targeting Gaddafi's palaces and command centres as well as his heavy weapons, being more willing to talk about regime change as, if not the primary objective, the indispensable means to achieving effective civilian protection, putting advisors on the ground, and almost certainly ensuring that the rebels receive weapons supplies, notwithstanding the arms embargo, all this then accelerates the risk of buyer's remorse from those who didn't oppose Resolution 1973, and it poses a real risk of a backlash when the next extreme responsibility to protect case comes before the Security Council. My own view is that the constituency which gave us Resolution 1973 is under real stress, but not yet broken. If it's to remain that way, it's crucial that NATO does not test the limits of the resolution any further than it has already. Unless and until another Security Council resolution can be negotiated, putting the military intervention on a broader footing, legal footing in terms of threats to international peace and security, rather than just a responsibility to protect civilian protection footing, which is, I have to say, extremely unlikely, unless that happens, the only course to adopt is patience. Waiting for the combination of military pressure, targeted sanctions, the threat of International Criminal Court prosecution, and I have to say the soft landing that's still potentially on offer from backroom political negotiations. It's a matter of waiting for them to have the effect that I think they very likely eventually will. Well, moving from the lessons that we've learned in the past and are still learning in Libya today to the challenges that still lie ahead for responsibility to protect, there are three distinct kinds that, apart from the obvious ones of holding the line after Libya, there are three distinct kinds that have to be met, conceptual, institutional and political, if responsibility to protect is to be established not only as a benchmark ideal, but as rock-solid reality. The conceptual challenge, about which I want to say most in the remaining time, is to secure close to unanimous understanding of just what kinds of real-world cases the norm is meant to embrace and what kind of policy response each such case demands, case by case. This hasn't been easy to achieve, but as time goes on, it's clear that consensus is growing, at least as to what are clear responsibility to protect cases, if not always what to do about them. With Darfur, Eastern Congo, Kenya, Sri Lanka being preeminent examples of cases accepted as responsibility to protect ones in recent years, and Côte d'Ivoire and Libya, of course, now being very explicitly recognised as such by the Security Council. Consensus is also growing on what are not such cases, in particular the coalition invasion of Iraq in 2003, even though Tony Blair desperately sought to invoke human rights concepts, and in particular the emerging responsibility to protect concept, and I lost a close personal friendship with him over that, I have to say, because I didn't agree with him. In particular, the coalition invasion of Iraq in 2003 and Russia's invasion of Georgia in 2008, which rather cynically invoked the responsibility to protect principle in circumstances where nobody else in the world thought that was an appropriate way of describing what the Russians were up to in South Ossetia. There's also an increasing willingness to recognise that there have been some more ambiguous cases, the most prominent example in this respect being, I guess, Burma, Myanmar, in the immediate aftermath of the 2008 cyclone, when it appeared for some time that the military government was being recklessly indifferent to large-scale loss of life, to the extent of possibly being about to commit a major crime against humanity. In the event it did accede to international aid relief engagement, and the problem was no longer characterisable in those terms, but it led to a lot of uncertainty in international argument at the time. I think the bigger need right now is not to reach agreement on what are responsibility to protect cases. That's becoming very close to a complete reality, but rather to reach consensus on what to actually do about them, case by case, and in particular, what to do about these cases when what's in issue is whether it's right to use the most extreme form of policy response, coercive military force, the debate which again has now been set alight by the intervention in Libya. On the question of legal criteria, there's not much room, I think, for anyone to manoeuvre, and not much practical disposition now to do so. It is generally acknowledged that self-defence apart, covered by Article 51 of the UN Charter, which is not really relevant here, apart from that, the threat or use of coercive military force against another state can only be legal under international law if it's expressly authorised by the UN Security Council under Chapter 7 of the UN Charter. Although one qualification, I think there is a growing acceptance that Chapter 8 of the UN Charter does allow some additional room for such action when it's taken by a recognised regional or sub-regional organisation acting within its own agreed rules, at least when that action is ultimately later endorsed by the Security Council. Although there are still some grumbles about this narrow legal formulation, what's legal when it comes to the use of force, still some grumbles about that, particularly in the United States, it's really not seriously contested anywhere else, that so-called coalition of the willing action taken without any form of UN authorisation must be seen as unlawful. The only qualification to that being that if that action is taken according to more or less overwhelming international sentiment in a manifestly principled way against the kind of criteria I'll come to in a second, then there's a fair chance that that illegality will be regarded as such, as illegality by the wider international community, but as being somewhat mitigated by the circumstances, in rather the same way in domestic law, the fact that your wife's about to have a baby in the back of the car or your father's dying in a hospital ward doesn't get you off the hook from running a red light, but it's sure as hell a pretty good plea in mitigation to when it comes to penalty. And I think that's a simplified but nonetheless realistic way of arguing the issue of legal authority for the use of military force. The issue on which real progress is needed, the conceptual challenge, and which I think can be made in the period ahead, but it's going to be slow, is the development of a set of criteria of legitimacy, as distinct from legality. Prudential criteria, if you like, for the coercive use of force. Such criteria were recommended by my own commission again by the Secretary-General's high-level panel on threats, challenges and change, which I also served in the run-up to the World Summit in 2005, and by Kofi Annan himself in his own report, In Larger Freedom, to that World Summit. These criteria have not yet been formally adopted by the General Assembly or the Security Council, and are really still only background noise in the current international debates. But I think their practical utility, combined with their long philosophical pedigree, most obviously in the Western Christian just war tradition, but with plenty of echoes of these principles in other religious and cultural contexts, I think all this justifies them being much more visible. And when properly understood and applied, I think it becomes very much easier to deal with the familiar arguments about hypocrisy and double standards in this context. Why strike in Libya but not in Darfur, or Yemen, or Bahrain, or Syria, for that matter? If Libya and Côte d'Ivoire were right calls because of what Gaddafi was doing or threatening to do to his own people, why wasn't Iraq in 2003, given Saddam's many crimes against his own people? What credence can the responsibility to protect principle have when we know that however bad things might get in Tibet or Xinjiang or in the northern Caucasus, military action against China or Russia will always be off limits? I think these criteria can help us answer those questions and steer a course between them, and I'll try and just hint at why. The first test, which is recommended to be applicable here, is seriousness of risk. Is the threatened harm of such a kind and scale as to prima facie justify the use of military force? The risk of an imminent civilian bloodbath was, I certainly believe, and the Security Council certainly believe, just as real in Benghazi and Abidjan in Côte d'Ivoire in recent weeks as it was in Rwanda in 1994. By contrast, there was no such imminent risk in Iraq in 2003, although there certainly had been a decade and more earlier for the Kurds in the late 80s, the southern Shiites in the early 90s. The current situations in Bahrain, Yemen, and above all Syria are on the cusp. Ugly, smaller scale, maybe not so small, much longer in Syria, and possibly still retrievable by pressure short of military action. Again, much more so in the case of Yemen and Bahrain than Syria. And I certainly would want to argue that the United States and its allies could usefully continue to apply much more pressure of that kind. The second test is whether the primary purpose of the proposed military action is to halt or avert the threat in question, or whether there's some other motivation actually looming larger. Libya passes that test, as would most of the other recent cases. Had oil or regime change been the primary motivator there would never have been Arab League or wider Security Council acceptance of military intervention. Russia, as I've already intimated, by contrast, found it very hard to find any takers for its assertion that the civilian protection was the primary rationale for its South Ossetian adventure in 2008. The third criterion is last resort. Has every non-military option been explored and found likely not to succeed? When I say explored, that doesn't mean you've got to wait for weeks and weeks and weeks and actually try the non-military options. It's a matter of making a reasonable man judgment, reasonable person judgment, that they would not, in fact, succeed. I've already suggested that Libya, and I'll do so again, that Libya followed the textbook here. Resolution 1970 applied coercive but non-military measures, and only when they failed to concentrate Gaddafi's mind did Resolution 1973, 3 weeks later, pick up the military option. In Iraq, 2003, lesser options had far from run their course, and the same is arguably true now for Bahrain and Yemen, and possibly also Syria. The fourth test is proportional means. Are the scale, the duration, the intensity of the proposed military action the minimum necessary to meet the threat in question? That's a very live issue in Libya at the moment. It's important, as I've already intimated, not to give any currency to the notion that modulated, proportionate force is something that NATO is incapable of applying. The final, the fifth, usually the toughest test for legitimate military intervention is balance of consequences. Will those at risk be overall better or worse off as a result of a coercive military intervention? That was always the showstopper in Darfur. Any attempted invasion of Sudan would have been disastrous for the 2 million displaced people in that country, and it would also, I think most people believe, have reignited the even deadlier North-South conflict, which was just holding together the peace in that respect, and hopefully still holding together now after the recent referendum. This will also always be a defensible explanation for the effective immunity of China, Russia, or any other major power, however badly it behaves towards its own people internally. It's not a matter of shameless double standards, so much as acknowledging that in these sorts of cases, any military action from outside would trigger a much greater conflagration with terrible consequences for many more people than those originally at risk. Resolving Libya's agony is going to take, I think, more than military action. But as in Côte d'Ivoire, it's hard to even begin to argue that the use of military force that we've seen, are still seeing, will cost more lives than it saves. So I think, again, Libya passes that test. And I think those tests, as I said, are helpful. And the conceptual challenge is to try and get general acceptance for them, if not formally in the Security Council. Adoption of guidelines, which I hope will ultimately be the case, at least in terms of an informal acceptance of their reality and their force. I think it will make the achievement of consensus on these cases much easier in the future if there is agreement that these are the questions that should be asked. And every one of them is asked with equal force and intensity, and answers are sought. Much more quickly on the remaining two challenges, institutional challenges. An awful lot to say about this, but let me keep it to just 3 or 4 sentences. The institutional challenges are essentially threefold: to ensure that there are early warning and response focal points established within all the key governments and intergovernmental organisations. The need, secondly, is to have in place civilian capability which is able to be utilised as occasion arises for diplomatic mediation, for civilian policing, other forms of critical civilian administrative support. And it's also critical institutionally to meet the challenge of having in place capable military resources which are available both for rapid fire brigade deployment in the most extreme cases which can't otherwise be addressed, like Rwanda, arguably again Libya, but also for longer haul stabilisation operations like those in Sudan and the Congo. Politically, what's the challenge there? Well, overwhelmingly, the biggest challenge in the future is going to be, as it invariably is in these cases, political. I think we can readily enough now envisage a future, hopefully not too far away, in which almost complete conceptual consensus will have been achieved on what are responsibility to protect cases and what are also the most appropriate measures to deal with them by way of prevention or by reaction. I think we can also envisage a future, perhaps a little further away, in which all the necessary institutional preparedness has been done, with the necessary early warning response, civilian and as necessary military resources being ready and in place. But we can certainly envisage, in such a future, governments and the international organisations they control still being reluctant to take the necessary decisions to act, particularly when the expenditure of national treasure or, even worse, blood is potentially involved. In any difficult situation, inertia will always be the default option. There will always be excuses, and that's, again, one of the reasons it's so important in Libya right now for NATO not to give excuses by overreaching its mandate to those states who will always be looking for excuses. Generating the necessary political will to do anything hard or expensive or politically sensitive or seen as not directly relevant to national interest is just a given in public affairs. internationally as it is domestically. The point is that the absence, and I say this over and again, the point is that the absence of political will should not be a matter for lamentation, but mobilisation. Political will is not something hiding in a cupboard or under a stone somewhere waiting to be discovered if we're only clever enough. Political will always has to be painstakingly built. And the only way to do that is through the time-honoured trio of good information, good arguments and good organisation, good campaign organisation. About all of which there's again much more to say, but I won't say it now except to offer just these very few last words. To some extent, those of us passionate about making the responsibility to protect a reality will always be pushing at a partly open door. There is goodwill out there in the wider community, among government policymakers and decision makers around the world. There is, as we've seen, a basic willingness to accept and embrace the responsibility to protect norm and to ensure that we don't ever again have to confront failures of will, failures of action on the scale of Rwanda or Srebrenica, not just as a matter of national self-interest, but as a matter of our common humanity. But we also know from long, hard, depressing experience that mobilising that goodwill, actually producing the necessary action, are not things that just happen. They have to be made to happen. And that, ladies and gentlemen, is the responsibility of us all. Thank you very much.
Thank you so much, Professor Evans, for that very eloquent exposition of the concept of responsibility to protect. Now, Gareth has very kindly offered to take some questions. We do understand if you need to go and rescue a babysitter or something, but we can have at least 10-15 minutes of questions, and we've got some roving mics. So I'm going to open up the floor now. Who would like to be the first to ask a question? Arm in circle. Thank you.
I'll take from you.
Thanks, Gareth, for clarifying a number of things. Thanks, Gareth, for clarifying a number of things for me. But do you think should the principle of responsibility to protect should have been applied to protection of the people of Gaza against the Israeli military campaign at the end of 2008 and beginning of 2009?
I don't think there's any doubt but that the principle is applicable in the occupied territories situation in the sense that it's not sovereign Israeli territory, which is the usual context in which we think about responsibility to protect as something that happens behind sovereign state boundaries, but is a territory under occupation by a sovereign force. And there's no doubt that the responsibility to protect people against mass atrocity crimes is one that is owed by Israel to its people. In the past, there's actually been a little bit of unwillingness on the part of Palestinian interlocutors with whom I've discussed this issue to rush to embrace responsibility to protect because of just the point that I've made. Responsibility to protect has primary currency and traction and resonance and application in the context of situations occurring within sovereign state boundaries, and Palestinians by and large don't even want to make the concession that it looks like such a case. I think that's changing a bit in recent times, and as the responsibility to protect principle has been gathering traction and visibly surviving attempts by various spoilers in the UN General Assembly to knock it off and go back to the pre-existing absolute sovereign immunity, as it's been developing that traction and as more and more people in the developing world have come out in support of it and not just the familiar Western suspect, then I think a lot of people on the Palestinian side, in the Gaza context and elsewhere, are saying, yes, this is a case where this principle is applicable, and this is another reason why the international community should be a hell of a lot more responsive than it has been. So I don't think there's any conceptual problem about that. It's really just been a kind of political problem. And of course, there's been so much other visibility so much other spotlight on these situations, so many other bases on which to be exercised about breaches of international humanitarian law in the warfighting context, breaches of human rights generally, or alleged breaches. I'm not making judgments about this right now. There's been so much that there hasn't been the problem of generating an international attention, international response in what has otherwise been an attention vacuum, which is one of the reasons, of course, why we focused on the whole issue of responsibility to protect in order to energise a response in situations that weren't able to get it otherwise. So I think the short answer, no conceptual problem, and increasingly a willingness to characterise in those terms, which I'm quite relaxed about. Yep. I'm sorry, well, perhaps we ought to go around the room. Yeah, up the back. Or do you want to do this?
I can do
Okay, you do. Okay.
There's one up there. Sorry, Catherine, there's one down here too.
Well, up the back first and then you. Yep.
One of the interesting characteristics of the intervention in Côte d'Ivoire has been the French leadership of the military action. And so I was just wondering what your thoughts are on the French views on the responsibility to protect. Do they have a different interpretation?
Well, in an ideal world, you'd quite like the French not to be doing things in Côte d'Ivoire and form a territorial context, because it always rouses the old demons about imperialism and nostalgia for civilising missions and so on and so forth. But I think in this context it is perfectly defensible that they played that role. They were able and willing to do it. The situation in Côte d'Ivoire was a little bit complicated in the way that I said, because there were three separate agendas running. There was supporting the African Union and the regional organisation ECOWAS in ensuring that a democratic election that was won by Ouattara was actually honoured, that outcome. And secondly was the bootstrap thing, the self-reinforcing thing of needing military force to protect the team of peacekeepers that were already there. And that developed accelerated momentum and became a kind of a rationale in itself for further extensions of the mandate. But the mandate was pretty broad that was finally given to the international forces, and that was with the knowledge by the Security Council it was the French that was basically going to be exercising it. And there were specific references to using military force to deal with heavy weaponry and so on, all of which gave the French more than enough encouragement to do the job. And I think, by and large, it was done about as cleanly and effectively as it could have been done. And I think, basically, for the right motivation. There is a constant French disposition, after Bernard Kouchner's original authorship of the concept of droit d'insurance, to still yearn for the old humanitarian intervention formula, to yearn for the language, right to intervene, droit d'insurance, and to think of things in a rather one-dimensional military way. It was the French, Bernard Kouchner himself, that leapt into the fray in the Myanmar cyclone case, 2008, saying, well, signs of inattention by the generals to the needs of their own people, in we should be now going with airdrops and barge landings and so on, all troops deployed. The rest of the world's been a lot more cautious about that, and I think properly so, because every time you jump into a situation that is not ripe and very clearly satisfying the criteria, you run the risk of destroying the possibility of consensus in the future. So France is still the most gung-ho and nostalgic for the old humanitarian intervention view of the world, but I think they've realised, and I've spent an awful lot of my time arguing this out with Bernard Kouchner himself and lots of others. But I think that they are pretty supportive now of responsibility to protect and prepared to recognise that there is a broader, more nuanced concept that's out there, and it makes far more sense and gives them far more chance of getting the resources to do various jobs that need to be done if they operate within that conceptual framework rather than exercise too much nostalgia for the early one. I don't think that the prospect of censure by the Human Rights Council, as it now is in Geneva, would be likely to cause President Assad too many sleepless nights, or even 5 minutes worth. I mean, the truth of the matter is it was very useful when the Human Rights Council rather unexpectedly leapt into the fray on Libya and did pass a censure resolution, in fact suspending membership. But I mean, Gaddafi just had so much form with so many different countries. He was such a loathed and sort of character around the place that it was easier to build a consensus there than it's proved to be in others of these cases. That's not to say that those issues of naming and shaming, those strategies, those techniques, those measures are not valuable. They are. Not to say that targeted sanctions are not valuable. They are. Not to say that threats of action by the International Criminal Court are not valuable. They are. And I think all of those things should be well and truly deployed now with full force in the case of Syria. Syria is an extremely interesting case. I mean, I know the place reasonably well. I had a number of multiple-hour conversations with the old man, and I've had at least 2 or 3 with the son and the current president, who does come across as a more thoughtful and civilised character than some of his recent utterances would give credence in believing. But there's no question but that he's surrounded by a legion of dinosaurs. I mean, it is an absolutely entrenched regime, a very, very hard line, and for the most part, rather unattractive characters. And even though I think there's been a much better chance of reaching an accommodation with Syria on the regional issues than has been widely acknowledged, and that's been appreciated, I think, by US policymakers, which is one of the reasons they've perhaps gone a little bit softer on Syria than might otherwise have been expected. A deal has always been doable over the Golan Heights, and if you could take that out of the equation, you'd take an awful lot of the other ugly dynamic out of the Israel-Arab confrontation. But it's never been quite possible to pull it off, and I think the dynamic would have changed internally had that been pulled off, and some of those internal dynamics would have worked themselves out in a rather more civilised fashion. But you've still got that old guard very much in charge. You've still got a sense on the part of the presidency that they're a bit of a beleaguered minority, being Alawites in a country which that's very much a minority sect. And you can sense all the lack of confidence which is leading them to respond now as they are. But just to repeat where you came in, I think it'd be great if the Human Rights Council could be persuaded to do something. But of all the measures that are available in the international repertoire, that's not the one that strikes the greatest fear into the hearts of these rogues.
Thank you, Angus MacDonald, a former employee of yours.
Yeah.
I've
lived to tell the tale. Okay.
I just wanted
That's
to
usually the next
ask
line.
Just for your comment on, is there a distance decay effect in all this on the level of responsibility? For example, does Australia have a higher sense of responsibility to, say, the intervention or to responsibility to protect in the Solomon Islands or East Timor, to Libya, for example? I'm just wondering how the intensity of the responsibility is played out in a regional context.
I think there is very much a sense in which the future effectiveness of implementation of responsibility to protect is going to depend very much on regional organisations and a regional willingness to mobilise in response to these situations, right through the repertoire of responses from preventive and in particular the ultimate reactive ones. It just is the case that people feel strongest and have the greatest amount of political cover usually when it comes to domestic support being necessary for things in their own neighbourhood. And certainly that's the way it's playing out in Africa. That's where the support for this, much to the disgust of some of the post-colonial and anti-imperialist writers, there's been quite a lot of support for responsibility to protect in the sub-Saharan African context because people have recognised the scale of the evils that have been perpetrated and have regarded indifference as a worse sin than intervention. But they've always been more comfortable when it's being done by regional organisations and they don't have to invoke the outsider. So I think that dynamic is at work, and it's a good dynamic and it's properly at work. I mean, there's a little bit of an edge in your question about isn't it easier to be moralistic about things a long way away when there's not a high level of expectation that you do have to do something about it. But I think that would be a very unfair characterisation of the Australian government's, for example, response to current situations where it's been an active proponent. I think it was quite silly to say that Australia should have put its money where its mouth is by promising to send a couple of whatever the current brand of not very effective military aircraft is halfway across the world to do a job. I mean, when you had legions of NATO resources there on the doorstep, and you had a whole bunch of other NATO players like Spain and Italy and so on dragging their feet, I mean, it was entirely reasonable. And Australia, be it remembered that Australia is the third largest, I think at last count, humanitarian supporter in terms of the pure amount of money and resources that are going into humanitarian aid and assistance for Libyans at the moment. So I think, and that's been underreported, under-acknowledged, but it's true, and it's a demonstration that we have indeed been prepared to put our money where our mouth is. Australia was actually quite a strong voice right through the critical stages of the acceptance of the responsibility to protect principle. John Dowth was one of now our High Commissioner in London, another former staff member of mine, who, not for that reason, because he was under the Howard government after all during this period, but he owed no obligations to his former loyalty, but he was a very, very effective voice in rounding up support from the less than persuaded. Now, back in 2005, Australia has been a very active member of the Friends group of Responsibility to Protect supporters in the New York context. Australia has been a continuing supporter, quite generously, of the Global Centre on Responsibility to Protect, which does research and advocacy support both for global NGOs and for governments on this issue. So I think across government lines, we've got a pretty proud record in this respect, and I hope it will continue. Oh, we've got to be quicker.
John Blaxland from the Strategic and Defence Studies Centre here at ANU.
Yeah.
Chancellor, thank you very much for that excellent presentation. You talked about a number of conflicts. You talked about Iraq and one of the reasons why it doesn't apply there. We're now committed in Afghanistan, and there's part of the debate was what do we do, how do we get out, and some of the issues that are related to that affect human rights obligations. We're already committed to people, to causes there. I wonder if there's some application for R2P when we're already in a place like Afghanistan. What do we do? How does that apply?
I think it's pretty important to keep the concept of responsibility to protect fairly narrowly focused. I mean, linguistically, it's capable of expanding out to accommodate a whole range of human security concerns. Certainly, and it's certainly capable of, we have a responsibility to protect the women of Afghanistan. We have a responsibility to protect the civilians of Afghanistan from the kind of, ugliness that can be expected if rough and tough Taliban Sharia law is reinforced. But I don't think it's helpful. I don't really think it's helpful at all. I think it's important to distinguish the universe of conflict and conflict prevention and conflict resolution cases and the universe of human rights abuse cases from the much smaller universe of responsibility to protect cases. At any given time, there's probably 100 country situations in the world which justify international human rights concern, Human Rights Council or other means, including often quite tough coercive measures, sanctions and so on. Probably about 70 cases at any given time of conflict, about 100 odd human rights cases, about 70 odd conflict cases of the kind that my old organisation, the International Crisis Group, reports on every month, Crisis Watch. I think of it as a kind of Venn diagram of overlapping, and then in the middle of that, there's a little subset of all of them as the responsibility to protect cases where basically what's in issue are the 4 crimes as now defined. Not that ethnic cleansing is technically, as a matter of term of legal art, a crime, but it's a subset of war crimes or crimes against humanity. But is it genocide? Is it war crimes, a crime against humanity? Or is it ethnic cleansing? Cases where that's actually occurring or is imminently about to occur if really strong preventive action is not very quickly taken, or where it's perhaps likely to occur in a matter of months, 12 months or so, where you're seeing the early warning signs, hate propaganda on radio stations and so on, where again you fear, because of the history of the place, Burundi, say, Côte d'Ivoire in the past, where you fear there's going to be some horror if really effective hands-on engagement doesn't occur. They're the kind of cases that I think we're talking about. If you're talking about long-term structural prevention matters, addressing grievance, ethnic grievance, regional grievance, things of the kind that can build up over time and create conditions for mass atrocity crimes. Conceptually, you can characterise those as responsibility to protect cases as well, but by and large, I've found it more helpful politically building consensus for this concept to say, well, what you'd be doing in terms of preventive strategies and those long-term structural senses is exactly what you'd be doing to address human rights problems, exactly what you'd be doing to address potential for conflict outbreak. No need to characterise it as responsibility protect stuff. And if you do characterise it, you sort of enlarge the universe of responsibility protect cases and make it that much harder to get the consensus you need when the smaller group, 12, 15 perhaps at any given time, are an issue. So for that rather complex, long-winded reason, I would resist describing Afghanistan as anything other than a combination of conflict problems and human rights problems. I wouldn't cast it in those terms, any more than I would follow my dear friend, the former Foreign Minister of Canada, who launched this commission, got very excited about it to the extent he went around the world for about 5 years thereafter saying there's a responsibility to protect, among other things, the Inuit of the Arctic Circle from the potential ravages of climate change. I think, okay, Lloyd, maybe you're right linguistically, but it's just not helpful in generating the kind of consensus we want, and that's the sort of answer I give to you. Sorry, a couple more and then leave it at that. Well, I'm relaxed, but...
Perhaps one last one. Security is going to be kicking us out.
Oh, okay.
So
I mean, you're going to have to pay for something. One more.
There's one here.
The longest and perhaps most successful humanitarian intervention of the last 20 years was in the mountains of Kurdistan after Gulf War I to protect the Kurds from what would otherwise have been mass murder in the mountains. One has to say that came immediately after one of the most egregious failures, which was to stand by and watch the Shiites who rose against Saddam Hussein in Basra, while we, myself among them, stood and watched it from over the border. To what extent have these events been instrumental in preparing the ground for the responsibility to protect doctrine? And also, while we're on the subject of colonial interventions or post-colonial interventions, could you say a word or two about Sierra Leone and the successful British intervention there, which brought to an end a very nasty mass murder?
Well, all of these cases did become very much part of the mix that we were taking into account in formulating this doctrine and have been helpful in one way or another in advancing it. Some of them have sort of confused things a bit in the sense that why wasn't what happened with the southern Shiites in the early 90s in Iraq enough to justify going to an interventionary war against Saddam Hussein in 2003? The short answer, I think, is that if you could take into account things that happened a decade or more ago, there'd be a fairly open-ended excuse to, I mean, for example, invade Robert Mugabe's Zimbabwe on the basis of what he was doing to the people of Matabeleland in the 80s. I mean, you do have to have a sense of currency or imminence about it. It doesn't mean you don't take action against these ugly characters, and there's every reason in the world for sanctions and all the toughest measures you can, but if you're talking about military intervention for civilian, for human protection purposes, then I think there has to be imminent or feared mass atrocity crimes rather than reprisal for, or using it as an excuse for something that happened before. By 2003, Saddam Hussein was, I'm afraid, just a common and garden tyrant of the kind that was fairly indistinguishable from maybe 50 or 60 other cases around the world. And that was the conceptual line you had to weave. But the success of the no-fly zone and the other operation to protect the Kurdish people in the aftermath of the horrors that they experienced a few years earlier was, I think, one of the things that did feed the perception that, yes, effective international action is part of our common responsibility and it can be made to operationally actually work. And I think you're right again in saying that the British excursion into Sierra Leone, which was very effective. I mean, at the same time, I seem to remember there was a US warship about 12 miles offshore, wasn't about as effective as an ashtray on a motorbike, while the Brits went in and did the hard work. Did it very effectively and demonstrated exactly the kind of thing that could be achieved with a highly trained military force, involved essentially in a gendarmerie operation. It was it wasn't a major military operation. It was exactly the kind of operation that had been mobilised in the early days of Rwanda. Cracked some heads, and worse, after that early spate of machete murders in Kigali and elsewhere, I think that would have stopped stone dead in its tracks, as it basically did in Sierra Leone. So there were good experiences of that kind, but It was very important not to get too excited about just the military dimension of this if we were going to build a consensual basis for action in the future. It had to be given the preventive dimension. It had to be given a very clear focus on the Security Council authorisation if you're going to use military action, not just freelance coalition of the willing operations. All of that has been part of the process of building the kind of consensus that we have seen in operation in Libya and Cote d'Ivoire now. And may that continue, but it's very fragile right now for all the reasons that I spelled out. That's it.
I'd like you to join me in thanking Gareth for his generosity and the wonderful